All right, welcome back, everyone. Our last two speakers we are on the home stretch, so here we go. Our next speaker is Professor William LaPiana. Professor LaPiana is the Rita and Joseph Solomon Professor of Wills, Trusts, and Estates, as well as the Director of Estate Planning Studies in the Graduate Tax Program at New York Law School. Professor LaPiana holds both a PhD in history and a JD from Harvard, where he also received his BA and an MA. After graduating from Harvard Law School, Professor LaPiana spent 4 years at Davis, Polk & Wardwell's New York office. Professor LaPiana is the author of several articles on estate planning, numerous articles in American legal history, and has authored several books. He has also been active with the Trusts and Estates sections of both the New York State and the American Bar Associations. In 1992, he was elected an ACTEC Academic Fellow. Currently, he is a member of the Board of Directors of ACTEC Foundation for a 3-year term which ends in 2015. Professor LaPiana's presentation today is titled, Married Same-Sex Couples Living in Non-Recognition States, a Primer. So please join me in welcoming to the stage Professor William LaPiana.
Hear me all right? Okay, so I was sworn in as a member of the Bar of the State of New York 34 years ago last month. In those 34 years, I've watched one generation skipping transfer tax and one carryover basis regime come and go. I've watched the tax law in general completely transform itself. Our property law has completely transformed. The third series of restatements, the Uniform Trust Code, the Uniform Probate Code, the Uniform Prudent Investor Act have completely revolutionized the ways, or at least begun to, the way trusts and estates are administered, the way documents are drafted. No one, I would never have suspected back in 1980 that the rule against perpetuities would be dead as the proverbial doornail, given all the effort I had to put into learning what it did, or that the Asset Protection Trust would exist. Of all, and not to mention medical technology. Today we know exactly who the father is. We can prove paternity precisely. But parentage has become infinitely more complicated because assisted reproductive technology and the possibilities of posthumous conception, ideas absolutely unthought of a generation ago. But nothing, I think, has surprised me more or has been less anticipated or could possibly have imagined that today 17 states and the District of Columbia would allow same-sex couples to marry. It's even more surprising because a generation ago, there were very articulate voices, most of them legally trained in the LGBT community, who did not hesitate to say that marriage was not the goal, particularly informed by the history of marriage, the unequal relationships between spouses, that there had to be better ways to organize relationships and families. That belief has vanished for a lot of different reasons, and at least not the least, legal reasons and changes that have made marriage a more equal economic partnership, whether it's changes in management of community property and community property states, or the rise of equitable distribution on divorce in common law title states. Now, the inner historian is going to quietly leave because the lawyer is going to drag him off the stage. I can speak the rest of the time about why all this has happened. But the idea now is to talk about what the world we live in right now, where, because of the existence of a federal system, a couple can be married in one state and yet not in another. So what I want to talk about, I think, is some of the aspects of this that may affect your clients, same-sex couples who want to marry for whatever reason, and then live back here in a state in which their marriage is not recognized. Now, the first thing we have to, it's going to seem odd to start this way, because I'm going to start sort of at the end of the outline, about page 30, because one thing we know is that where there is marriage, there is divorce. Now, this first wave of same-sex marriage has led to an awful lot of marriages between people who have been together for a long time. Edie Wilson and Thea Speyer are the paradigm. They lived together as a couple for 42 years before they married in Canada. Those marriages are overwhelmingly likely to end only with the death of one of the spouses. They've got it figured out. If there were children, they're grown. There are no more fights over raising them. The financial stuff has been sorted out. Who sleeps on what side of the bed? Long ago decided. Those marriages are going to last until death. But eventually, those marriages, and since I'm an academic, once a year I have to coin a new term. So they're ratification marriages is what I've decided to call them, simply ratifying the existing situation. Those marriages, the ones that are going to happen will happen. And eventually same-sex marriage and marriage between different sex persons will probably turn out to have relatively the very same divorce rate that we see today. Now, we don't think very much today about what it takes to get divorced because grounds for divorce are pretty much uniform across the United States. And we don't think much about migratory divorce. When my state, New York, allowed divorce only for adultery well into the 1960s, then we had a whole subgenre of melodrama, right, of people who went into Nevada to establish that short period of residency so they could be divorced on other grounds and return home with a divorce that would be recognized. Were it not for that, we never would have had the women, neither the play nor the movie. Today, we don't think much about that. We don't think about migratory divorce, but we have to again. Most states, except, believe it or not, Alaska, which I think if you think about it, there are probably good reasons for that, require some period of residency before a court will take jurisdiction of a divorce action. Sometimes it's 3 months, but usually 6 months to a year is what's typical. Now, why is that? Well, our courts will take care of our residents, but not people from elsewhere. 7 states that have authorized same-sex marriages by statute have included in their statutes provisions that allow couples married in that state to be divorced in the courts of that state without having to worry about the usual residence requirements. Now, the outline summarizes the statutes and describes them in some detail. There are 2 things about them you've got to recognize. One is, all but one, that's Illinois, says a predicate to jurisdiction is your state where you live won't divorce you. And then the statutes say, and if the state won't recognize your marriage, there's a presumption they won't divorce you. It's only a presumption. What's the law in Texas today? I have subscribed to one of these Texas Appellate Watch things, because how they decide Naylor would be really nice to know, but we don't know yet. The only state that's different is Illinois, whose statute says if a same-sex couple marries in this state, they subject themselves to the jurisdiction of the state for purposes of divorce. So instead of wiping out the residence period, it is a straightforward, you consent to having the divorce here. That's probably the clearest state in which you can have your divorce done if you can't do it at home. So maybe Illinois would be the choice. What you got to realize is no matter how you address this, the divorce will be under the laws of that state. Of the states that allow same-sex marriage, only 2 are community property states, Washington State and California. Washington State has no provision like this. There you've got to be a domiciliary to be divorced. And in California, if you divorce in California, they have this little idea called quasi-community property. Everything that would have been community property had you acquired it in California while you were married is community property. You want to get divorced there, it's called hire a forensic accountant. The other states are common law title states, where division of property on divorce is totally different, of course, than what it is in a community property state. It involves a concept called equitable distribution, and obviously one could never go forward without someone competent in the matrimonial law of that state. And indeed, if your same-sex couple clients really are thinking that's far ahead, and particularly if there could be large amounts of wealth involved, so they really want a prenup, that prenup will have to work under the laws of the state in which they were married and whose courts they contemplate using if they divorce, which will be a lot of fun if the state they live in will eventually come around to divorcing them. And so they've got this prenup based on the law of a common law title state, and now they're living in a community property state that really will divorce them. Fortunately, I'm not a matrimonial lawyer, let alone one competent in the law of all 7 of those states. That's something you really have to keep in mind. I have friends in New York who have clients who are same-sex couples, some of them of considerable assets, and sure enough, they're picking out where to get married based on where they will most easily be able to get a divorce resolved if it comes to that. So that's the first thing you've got to keep in mind. Now, let's say, okay, you do get married and you come back to a non-recognition state to live. What's the effect on your life, at least on your legal life? Well, first and foremost, for most purposes, for most federal purposes, you're going to be married. And I don't have time to go through all the variations of this, so we'll concentrate on 3 federal departments that affect most of our lives: Treasury, Labor, and Health and Human Services, i.e. taxes, ERISA, and Social Security. Now, starting on page 15 to 16, we've got what Treasury tells us. And the various Treasury, the various rev procs are set out there. Basically, for all federal tax purposes, the couple is married no matter where they live. That means they will file their federal income taxes jointly. The marital deductions will be available for all transfer tax purposes. And the big effect on generation skipping transfer tax, of course, will be generation assignment. Now, this is a lot easier for married same-sex couples living in Texas or Florida, where there is no state income tax and there is no state estate tax. Same-sex married couple living in states that do not recognize their marriage will have to do the exact reverse of what couples in states like New York and Massachusetts had to do before the Windsor case, which was we have to file separately federally and jointly for state purposes, so you end up with, you had individual federal returns, a pro forma federal joint return from which you created the state return. In states that do have state income taxes, we now have the reverse, except for Missouri, which is allowing same-sex couples to file their state taxes jointly. And a couple like Virginia and Wisconsin have actually come up with forms to try to make it easy to move from one filing status to the other. But that's not a problem, obviously, here, because you have no state income tax. The married couple then faces what every married couple faces when it comes to federal tax. Will there be a marriage penalty or a marriage bonus? And it's hard to know. Generally speaking, if one spouse has quite low taxable income, the other relatively high, doing a joint return probably will lower the overall income tax bill. If they're relatively equal, probably won't. And that may change from year to year. One of the spouses has a small business that's an S-corp or an LLC. 1 year losses pass through. That might very greatly reduce their joint tax bill because it's going to offset a lot of the other spouse's income. The truth is that getting married on deciding on what it's going to do to your federal income taxes is silly, because you really don't know. As far as the transfer taxes go, of course, planning for this hypothetical same-sex married couple is the same as for any married couple. There will be portability of unused applicable exclusion amount. There will be an unlimited marital deduction if one is fortunate enough to have to worry about federal estate taxes to have that much wealth. And what's probably most important for day-to-day life is you don't have to worry about transferring property between each other during the course of the marriage because of the unlimited gift tax deduction, so long as both spouses are United States citizens, of course. This removes certain things that complicate a lot of lives of unmarried couples and same-sex married couples whose marriages weren't recognized by the federal government. Classic hypothetical case. The residence is owned by one of the spouses. The spouses would love to hold it as joint tenants with right of survivorship, to move it out of probate. You turn that into a joint tenancy with right of survivorship, you have a gift from the owner's spouse to the other spouse of one half the value. Before, well, not so significant now that the exemption is so large, but certainly up until very recently, that could be a real worry. Doesn't matter now. Unlimited marital deduction. One of the spouses has quite a bit of money, the other much less, so the wealthier spouse pays for the trips, the vacations, all that kind of stuff. The majority of the household expenses, doesn't matter. Unmarried couples still, of course, but same-sex couples who could not or whose marriages weren't recognized, you become really compulsive record keepers. So you can show that each person paid 1/2 of all those expenses. Those problems are gone because of the way Treasury is treating this. Now, there's a lot more in here on what Treasury is doing about employment taxes, about cafeteria and flex plans, all of which pretty much amount to you're married no matter where you live. The Department of Labor is important, of course, first and foremost, because its regulations principally talk about ERISA. And the decision that Labor has made, as explained in the outline, is that for ERISA purposes, they're going to follow what Treasury does, which is a place of celebration rule. If you got validly married, you're married, no matter where you live. This means, of course, that the spouse has rights, or that spouses have rights in each other's employment benefits. And as we know, at least for some plans, that means you must take that benefit as a qualified joint and survivor annuity, unless the other spouse makes a valid notarized waiver of the right to require that. This sounds easy. It's not. Because, of course, some employer plans are going to exist only in states that don't recognize the marriage. But presumably, at least as far as we can tell, for ERISA purposes, and, unless you comply with ERISA, the whole thing's not going to work. You've got to treat this couple as married. Now, towards the end of the outline, there's the Cozen-O'Connor case, which is the thing that comes closest to addressing this. That involved a same-sex couple who married in Canada, lived in Illinois, where one of the spouses worked for Cozen-O'Connor. She was a partner. And they entered into an Illinois civil union. There's a whole lot of stuff in here about the marriage substitutes that existed for a while and are quickly dying out as they're replaced by marriage. And, of course, the partner died, and without designating a beneficiary of the pension benefit and the other employment benefits, the life insurance, the pension benefit itself, and the plan document said, in the absence of a designated beneficiary, who do you think your beneficiary is first? Your spouse. If not the spouse, the parents. So we get a lawsuit between the parents and the surviving spouse over the pension benefits. Now, the plan is headquartered where it's administered where Cozen-O'Connor's principal offices are in Philadelphia. Pennsylvania does not recognize same-sex marriage. The only state in the Northeast that doesn't. And the District Court for the Eastern District of Pennsylvania, the federal court says the surviving spouse is the beneficiary. Why? Because of ERISA preemption and Windsor. Once the federal government is going to recognize that marriage, ERISA preemption means the employment benefit plan must too. Now, it's a little more complicated than that, because they had been in a civil union in Illinois, and an Illinois court rendered a judgment that said the survivor was the surviving spouse. Now, is that enough to make the result different if they had been living in a state that didn't recognize the relationship at all legally? We don't know. But the language about ERISA preemption is pretty strong, and I would think that now any employment benefit plan governed by ERISA is going to have to recognize the marriage. When, however, it comes to the Family Medical Leave Act, the Department of Labor has taken a place of residence rule. In other words, the Family Medical Leave Act rights depend on where the employee is. So presumably, a Texas employer does not have to give federal Family Medical Leave Act benefits to a spouse in a same-sex marriage. Doesn't have to recognize the marriage. Now, again, all this is, I suppose, certainly is susceptible to change, but that's where we stand now. Now, Social Security. Anyone who has ever worked at all, right, has got some interest in Social Security. And it's particularly important for spouses because, as I'm sure you know, when spouse 1 applies for his or her Social Security, spouse 2 is entitled to their own independent benefit equal to 1/2 of their spouse's benefit. Now, it gets a little more complicated than that, obviously, but that's the basic rule, and that's what we need. So the question is, same-sex couples validly married, does the right to that spousal Social Security benefit depend on where they live? And the answer is sort of. As the outline explains, Social Security has taken what I have now learned from my students to call a nuanced view of this. In the earlier part of the outline, I reproduced with my emendations the table that Social Security published in the release, the link to which you have in the outline, which shows date same-sex marriage first recognized in state, date couples were allowed to marry in state. Now you have to understand that, number one, some of it's already out of date, so the stuff in italics I have added, and even that's wrong, because Illinois wasn't going to start allowing same-sex couples to marry for a couple of months because a court decision pushed that forward, so same-sex couples are marrying in Illinois now. And there are really complex questions in states where there's a transition from civil union to marriage. And again, that's all in the outline. Not very relevant to a state where same-sex couples have never had legal recognition, but certainly will be for some. The bottom line is that the spouse is going to get the spousal benefit if the number holder, this is a Social Security term of art I only learned from doing this. That's the employee, the person who was employed, who's got the Social Security number, who's applying for his or her own benefits, is in a state that recognizes the marriage, either when the application for their benefits is made or sometime while the application is pending. Now, for folks, say, in New York, the message is clear. Do not leave for Florida after you retire until you have applied for your Social Security benefits, then you're fine. What it means for a couple in a non-recognition state is if that spousal Social Security benefit is important, the number holder is going to have to remove him or herself for some period of time to a state where the marriage is recognized. We don't know how long. It tosses around, the Social Security Administration tosses around the words residence and domicile with an abandon that, I think leaves us a little frightened. The minute you talk about domicile, things get really crazy. So it's tough to know exactly what to do. Now, I've set out for you, and you'll have to forgive me because the page numbers have changed in the way it was printed for you. This is going to be about page, probably 17, but it's under Social Security Administration. I've set out the examples that the release from Social Security Administration has set out. And the most important one is probably on page 20, I think, involves Susan. So Susan, who's the spouse who's claiming, and Gail, who's the number holder, are domiciled in Mary in Massachusetts when it becomes legal to do so. Susan files for spouse's benefits on Gail's record where they're domiciled in Massachusetts. While the application is pending, Susan and Gail move to and become domiciled in Texas. They meet all the factors of entitlement. The spouse's claim is approved because when filed, they were domiciled in a state that recognizes same-sex marriage. So, and the date of filing in Massachusetts is the date of entitlement, which is a term of art for Social Security purposes. So again, New Yorkers don't move to Florida once you retire until you've made that claim. The one that is relevant, I guess we could say going the other way, is Brad the claimant and George the number holder marry in Massachusetts after Massachusetts recognizes same-sex marriage. They were domiciled in Massachusetts. They moved to and become domiciled in Texas. Brad files for spouse's benefits on George's record while they are domiciled in Texas. They meet all other factors of entitlement. Hold the claim. That's Social Security's lingo they're using for don't approve it. It's quite clear they're waiting to see what happens. It never says deny the claim. It says hold the claim to see what happens. Now again, in order to be unequivocally entitled to those benefits, the number holder is going to have to be apparently domiciled in a state that recognizes the marriage when the claim is made. Whether or not that's actually practical or worthwhile is something else entirely. Now, lots of other federal aspects of this. Federal employees, of course, are married no matter where they live, entitled for employment benefits on a spousal basis. The military has decided that service members are married no matter where they live, so that their same-sex spouses are entitled to care under TRICARE, to housing allowance as a married couple. The Department of Defense has gone so far as to allow service members stationed in states where they cannot marry non-chargeable leave, that is, not against basically extraordinary personal leave, to go to a state where they can get married, to get married. So for certain service members, clearly, this is something that you can, I suppose the term is, take advantage of. And of course, the Justice Department just a few weeks ago announced that for as many federal judicial purposes as they can, same-sex couples are married. Therefore, the usual spousal evidentiary privileges will be available in federal court cases, no matter where the federal court is located. Spousal prison visitation rights will be the same, no matter where the prison is actually located. And that certain benefits, federal benefits, for the surviving spouses of law enforcement personnel killed in the line of duty will be available to people, surviving spouses of a legal marriage, no matter where they are resident. That's the general framework. It's moving too fast, in a sense, for me to tell you anything definitive. I have never before done a CLE outline that went out of date so fast. Let me just give you an example. Since I said this thing, since I told Riley, okay, I got the ultimate extension I could, you got to love it when you got professors asking you for extensions. What has happened? You've had a federal district court in this state say the ban on same-sex marriage violates equal protection. The Utah case happened. In a short period of time, 1,300 same-sex couples got married. I don't know how many of those are what we called ratification marriages, but that shows you what the economists would call, I think, the pent-up demand. We've had a court in Kentucky say that Kentucky must recognize same-sex marriage as valid or celebrated. The interesting thing about those cases is that they don't have nothing to do with full faith and credit. They are all premised on equal protection. So a lot of the academic ink that's been spilled over whether or not the full faith and credit requirement in the federal Constitution is at all applicable to marriage recognition seems to have been just that, spilled academic ink. Where full faith and credit will become important, however, and here we can sort of go back for a minute, we've got our married couple, resident of the state where they can't get divorced, who have carefully chosen the state where they married, so if they want to get divorced, they can get divorced. So they get divorced. And by the way, if you look at it carefully, the best one I think is Vermont, where the required hearing, if there are no controversy, can be done over the phone. Well, if people can't come there and there's no real controversy, it's a simple divorce, why not? But then you get an order dividing up the property, and some of that property is here. That's where there's going to be a full faith and credit problem. Because that's an order of a court of a sister state. And enforcing judgments is one of the things full faith and credit is supposed to allow. So that's where the full faith and credit controversy will happen. Now, I have no idea what the Supreme Court will do when this gets to them, which may come much sooner rather than later, and probably perhaps much sooner than the court itself ever wanted. So leaving that federal question then back to the state level. Our married same-sex couple living here in Texas or any other state where there's non-recognition, their planning is going to be the same as it always was, whatever planning you do for an unmarried couple. So maybe try to avoid the probate system as much as possible so that family members who are heirs in intestacy, since there's no legal recognition of the couple's relationship, there will be no will to try to contest, no way to hold this up for the people with the assets that make it worthwhile, once marriage is possible, you might want to think about creating a revocable lifetime trust of financial assets in a state where the marriage is recognized, governed by the law of that state. Delaware recognizes and allows same-sex couples to marry. There are more than enough Delaware trust companies happy to be the trustee of people with sufficient assets. You create a revocable lifetime trust there, governed by the law of that state with an in-state trustee. Your heirs, who might not be happy about your relationship, might not have much they can say about it. It might be an effective way to immunize your estate planning. But otherwise, it will be what it's always been. You have to make sure that all the durable powers of attorney are in place, that the healthcare decision documents are properly done to allow decisions for each other, even to allow hospital visitation when the time comes, if that's what happens. All traditional things we have done. Now, when it comes to children, it's far beyond the scope of this presentation, at least. I do know that very occasionally there have been second-parent adoptions in Texas. There's one unmarried couple. One is a parent. The partner adopts the child without severing the relationship between the birth parent and the child. What happens, for instance, when the same-sex couple validly married in State X comes to Texas with children who are the children of at least one of the spouses only because they were married, who knows what happens? Those parentage questions are kind of beyond the scope. The tax planning will be not to worry about state income or estate taxes. We only have to be concerned about federal stuff. And the last thing, this abbreviated because I want to end on time, about the only thing between you and the reception, is what about other people's documents? Now, the world is full of trusts and wills that talk about spouses. Clearly, if you may be married, but if you're a state that does recognize the marriage and you have a will, probably not the best idea, that describes you, don't describe that other person as your spouse. You can do it by name, for heaven's sakes. Why raise those kinds of problems? So in your own documents, that's easy enough to address. You're in control of those. But what about the wills and the trusts out there of relatives that talk about spouses? Not unusual for a trustee to be able to make discretionary distributions to the spouse of a beneficiary. A beneficiary may have a power of appointment to appoint to, among other objects, their spouse, or maybe at least an income interest in something to the spouse, at least while the surviving spouse remains unmarried. How's that going to work? Well, for existing documents, I say in the outline, my good friend Lee Fortritt, who teaches at the University of Florida, has suggested that it'll be like the old stranger to the adoption rule. You know, the rule used to be, if you adopted a child, that was your child, was also your spouse's child, you adopted together, but it wasn't your parents' grandchild, it wasn't your sibling's niece or nephew. You could create a child for yourself through adoption. You couldn't foist new relatives on your relatives. Now, that idea went away pretty thoroughly by the end of the last century, but the rule has developed that whether or not adopted children are included in a simple description of children or descendants sort of depends on when the document was written. You know, courts have, before a certain date, no. After a certain date, yes, unless you can show no. And after a certain date, certainly yes. And Professor Tritt's suggestion is that may be the way spouse works when it comes to same-sex marriage. I've thought more about it. I'm not so sure. After all, what the spouse means, it means the person to whom a beneficiary is married. And kind of married is married. It's not like, adoption is unknown to the common law, not the kind of thing that could happen without special statutes. The idea of a spouse is a pretty old one and pretty uniform, so who knows? What might be more important is drafting either to be sure in documents going forward that the same-sex spouse is either included or excluded. Included, even if you're going to be governed by the law of a state that does recognize the marriage, you can define what spouse means. The spouse of a beneficiary is anyone to whom the beneficiary is legally married under the law of the place where the marriage took place. That will do it, no matter where you happen to be. If it's the other way around and someone really doesn't want to include a same-sex spouse, then I suppose you could do spouse of a beneficiary. This is where it gets tough. It could be legally married under the law of, if Texas law governs the will or the trust, under the law of Texas. But of course, that may change. Sooner or later, it may. Once you try to describe who that spouse is going to be by gender, it gets kind of difficult. Spouse means what? Only someone who is legally married to the beneficiary, I suppose, who is not of the same sex as the beneficiary. That would work. Except, what about transgender persons? They once were of the same sex but are not now? I don't know. There's a certain irony here that exclusion is always more difficult than inclusion. And I think there's going to be a lot of creative drafting to try to deal with this. Now, in this relatively short period of time, that really is the 100-mile-an-hour trip through this thing. The important thing is it's going to keep changing, and it's something we really have to keep up with. I am pleased to tell you that one of the things I would never imagine 32 years ago when I was sworn in, no, 34 years ago, is that I would have in-laws. That seems to be a concomitant thing of having a spouse, which can be a good or bad thing, depending. I want to thank, first of all, the students of the Journal for the invitation. I wanted to thank, as everyone does, Jerry and Margaret for the fantastic job they do. One of the proudest moments of my life was to write one of the recommendations for the award of the Chancellor's Teaching Award to Jerry Beyer. It's the easiest recommendation I have ever written. And I also want to thank the students for making this just such a wonderful experience, and thank you for listening.